Before August hits, these 10 USCIS changes could impact your case. From new interview tactics to social media vetting, and from silent denials to harsher enforcement. Whether you're applying for a green card, renewing a work permit, or just trying to stay safe while traveling, this video could save your case. Let's break down the 10 USCIS changes that went into effect in July, and what you need to know before August 2025 begins. 1. USCIS adds new questions to marriage interviews. Marriage-based interviews are getting tougher and longer. Since mid-July, immigration attorneys have reported that officers are asking intent-based questions that go beyond timelines or proof of cohabitation, attesting couples on future plans, financial habits, and social media cross-checks, referring more cases for second interviews, Stokes interviews, than ever before. If your interview is coming up in August or September, start prepping with a mock interview. USCIS is now trained to look for fraud indicators, even in valid marriages, especially if the couple married soon after meeting. 2. Social media checks are now fully active. This is no longer a pilot program. As of July 2025, the U.S. State Department and USCIS are jointly enforcing a mandatory review of social media accounts for F, J, M visa applicants, students/scholars. Certain H-1B and L-1 cases flagged for national security review. Adjustment of status applicants under investigation. Officers are instructed to look for anti-American posts, engagement with banned accounts, signs of hostile intent or subversive ideology. According to the June 18th internal cable that leaked to the press, refusing to disclose your social media or making it private may now be used as evidence against you. 3. Form I-693 medicals must be submitted with your I-485. Starting July 1st, USCIS quietly began denying adjustment of status applications that don't include the completed I-693 medical form. Here's the change. Before, you had a 60-day window to submit it later after RFE. Now, there's no grace period. If your I-693 isn't in the initial submission, your case could be rejected entirely. Pro tip: always get your medicals signed by a USCIS-approved civil surgeon within 60 days of filing your I-485. 4. Work permits are now issued for just 6 months in many cases. Did you apply for an EAD recently? If yes, check the validity. Many categories are now getting 6-month approvals instead of 1 to 2 years. Applies to pending asylum cases, spousal green card applicants, DACA renewals in some states. This change was hinted at earlier in the year, but now it's actively being implemented in certain field offices. You'll need to renew more frequently, increasing the cost and stress for applicants. 5. Auto denials are up, even for tiny mistakes. 1 extra mark, 1 old form, 1 missing signature, and you're out. Since June 10th, USCIS has dramatically increased the rate of auto denials for submitting outdated versions of forms, omitting a single required document, leaving signature lines blank, even for interpreters. Attorneys are calling this a return to the zero-tolerance filing rule of the early Trump years. No RF. No warning, just a denial. 6. More denied cases are being referred to ICE. This is one of the most worrying developments. In late June, DHS issued a revised referral memo that instructs USCIS officers to notify ICE in the following cases: denied asylum, denied adjustment of status for overstays, a visa fraud or prior unlawful entry. In July, immigration law firms started seeing a sharp spike in ICE letters sent after a denial. This doesn't mean deportation is automatic, but it does mean risk. If your case is complicated, get legal advice before August. 7. USCIS is monitoring social media for hostile attitudes. Separate from the visa vetting rule mentioned earlier, USCIS now has a new protocol to flag posts from permanent residents, visa holders under monitoring, adjustment applicants under review. Here's what's dangerous. Satirical content or memes can be misinterpreted. likes, and follows are now being analyzed. Anti-government views may be categorized as subversive. Think of this like online behavior surveillance. One immigration officer anonymously said, "We're not judging politics, we're flagging risk." 8. More green card approvals via cancellation of removal, 42B. Not all changes are bad. As courts become overwhelmed, some immigration judges are more open to granting green cards under the 10-year rule, called Cancellation of Removal, 42B. Who qualifies? Lived in the U.S. 10-plus years continuously. Have U.S. citizen or LPR children, spouse, or parents. Can show exceptional and extremely unusual hardship. Have a clean criminal record. In July, legal aid groups in California and New Jersey reported a notable uptick in successful 42B decisions. It's still hard to qualify, but if you do, don't miss this window. 9. Green card holders must carry ID at all times, being enforced. This rule isn't new, but it is now being used more aggressively. Under 8 USC Section 1304(e). Every alien 18 years of age and older shall at all times carry with him and have in his personal possession any certificate of alien registration. That includes your green card, Form I-551. Failure to comply equals misdemeanor plus possible IC detention. In July, several LPRs were stopped near state borders and held until someone could bring their card. If you don't want to carry your physical green card, at least carry a clear copy or USCIS-issued digital proof, just in case. 10. July Visa Bulletin. Surprises in family and employment categories. The July 2025 Visa Bulletin brought mixed news. Family-based F2A. Still current for most regions, but slow processing continues. Spouses and minor children of green card holders still seeing 10 to 14-month waits. F4. Siblings of U.S. citizens. Barely moved. Some regions regressed a few weeks. Employment-based EB3. India saw a retrogression by over 7 months. EB2 and EB1 mostly stagnant, with no big forward movement expected until Q4. Final thoughts. July was a turning point. This month, we saw the Trump administration's immigration priorities accelerate, but in quiet, technical, and tactical ways. More denials without notice. More personal information under review. More IC overlap with USCIS cases. Yet also, more chances for long-term immigrants to get green cards under 42B. The system is rewarding preparedness and precision, and punishing even small errors or vague answers. So what should you do before August 1st? Double-check your forms and documents. Talk to a licensed immigration attorney if you're unsure. Clean up your digital footprint. Avoid political content on public accounts. Be ready to prove ties to the U.S., especially if you're traveling. Stay informed. Things are moving, and you don't want to be left behind. If this video helped you, hit like and share it with someone applying for a visa, green card, or work permit. Don't forget to subscribe and turn on the bell icon. We'll be breaking down the August Bulletin and leaked DHS memos very soon. Thanks for watching. See you in the next video.